Welcome to another lesson in Federal Civil Procedure. In this video, we're covering service of process. If you're familiar with my lessons, you know I usually give you a step-by-step roadmap, and here it is. This roadmap is a summary of what I will cover in this lesson. Alright guys, so I made a video on this topic due to student demand. It's not a complex topic at all, but it is highly tested. Thankfully, service of process is an incredibly interesting area of civil procedure. And that's a complete lie. The topic is bland and painfully boring. So, my plan is to go through it quickly and mechanically with a checklist. We are going to learn the what, why, when, who, how, where of service of process. What is service of process? Why does it matter so much? When must it happen? Who can effectuate service of process? How is it done? Where is it done? We're also going to cover waiver and immunity. So put your phones away, silence your notifications. Don't put yourself in a situation where you have to keep rewinding and rewatching this boring topic. Let's rip out the Band-Aid. I'm going to try to make it as least boring as possible. Let's begin. What is service of process? Easy peasy. Proper notice of a lawsuit to defendants. That's it. Service of process is about proper notice to a defendant of a pending lawsuit against her. The due process clauses of the 5th and 14th Amendments require that plaintiffs notify defendants about pending lawsuits. The means of providing notice of a lawsuit to a defendant is generally referred to as service of process. Process are the documents that a plaintiff must provide to a defendant to give proper notice of a lawsuit. Those documents are usually a copy of the complaint, and it makes sense, right? A defendant needs to know what are the allegations enumerated against her, and two, a summons directing the defendant to respond or appear in court. Service refers to the delivery of those documents to the defendant, to the method of delivery. Hence, service of process concerns how a plaintiff notifies the defendant about a pending lawsuit. Done with a definition of service of process. Next, why does it matter? There are a few answers to this. For purposes of law school or the bar exam, service of process matters because it's tested. On a deeper level, on a more substantive level, it matters because of the Constitution. The 5th and 14th Amendments of the Constitution forbid the government and the states from depriving any person of life, liberty, or property without due process of law. This means procedural due process and substantive due process must be met. Procedural due process means fair judicial proceedings, notice, opportunity to be heard, and an impartial tribunal. Substantive due process is a principle to prevent government encroachment, government interference with fundamental rights. In this lesson, we're covering this part right here, notice and opportunity to be heard. In con law and in criminal procedure is mostly where you will get into fundamental rights. This is what we're covering here. So, service of process matters because it's highly tested, because it deals with our constitutional rights, and as a practical matter, service of process matters because it can get your case dismissed. It is important that the plaintiff serves, that the plaintiff notifies the defendant properly, because the defendant can move to dismiss the case for insufficient service of process. And there you have it, 3 good reasons why service of process matters. Next is, when must it happen? When must service of process be effectuated? And the answer is 90 days within the filing of the complaint. And this period may be extended for good cause, so you can get an extension on serving a defendant depending on what your reasons are. After 90 days without service, the court must, pay attention to this word, the court must do one of the following. Dismiss the case without prejudice as to the unserved defendants. As to the unserved defendants only, the court does not have to dismiss the entire case. Or order service be made within a specified time. Or if the plaintiff can show good cause, if the plaintiff has a good excuse for not yet serving the defendant, extend the time for service for an appropriate period. And timing for foreign defendants is a little different and is a little bit more lenient. There is no time limit really for serving a foreign defendant under Rule 4. Courts generally consider whether the plaintiff has taken reasonable efforts to effect service. So there's a lot more leeway. Okay, done with timing. Next, who can serve process? Who can effectuate service? To serve process, a person must be at least 18 years old and not a party to the lawsuit. Boom, look at us, done with that. Next is where the meat lies. How is it done? Where is it done? What about waiver? We will cover them all one after another. And the key term here is sufficient method of service. To be sufficient, a plaintiff's method of service must 1. Satisfy due process and comply with the relevant procedural requirements. Let's begin with satisfying due process. To comply with due process, the plaintiff's method of service must be reasonably calculated under all the circumstances to appraise interested parties of the pendency of the action and afford them an opportunity to present their objections. And this test comes from the seminal case, Mullane v. Central Hanover Bank and Trust. In short, the plaintiff's chosen method of service must be reasonable under the circumstances to give defendant actual notice. And actual notice, by the way, is when a party is directly informed of something, when they're actually informed of something that could affect their interest. Alternatively, for example, constructive notice is when information is made available to the public and the law assumes the person has received it. We want the defendant to have actual notice. The balancing test in Mullane weighs the defendant's rights at stake in the lawsuit with the plaintiff's burden of giving actual notice to the defendant. The greater the risk at stake for a defendant, the more perfect the notice that a court will require. So a service method is reasonable if it is reasonably certain to inform the defendants of the lawsuit. Now, I want you to keep in mind at all times that whether service is reasonable under the circumstances is defendant specific. And if the plaintiff is suing multiple defendants, then the plaintiff must undertake the best service practicable for each defendant. And this may require different methods of service for different defendants. Remember, there usually isn't just one party on each side of the V. There are usually multiple plaintiffs or multiple defendants, and each defendant must be notified of that lawsuit properly. Now, let me talk about defendant specific for one more minute. Service of process being considered reasonable under the circumstances is defendant specific because it depends on the individual defendant situation. And this includes their location, accessibility, and any unique circumstances that might affect how they can be properly notified of a lawsuit. Meaning the method of service that is reasonable for one defendant might not be reasonable for another. Courts generally have found the following forms of service reasonable under the circumstances. Serving the defendant personally, that is the king. That's the one that's the preferred one, right? But it's not always possible. Serving the defendant via registered mail, return receipt requested. Serving the defendant's authorized agent. Serving a responsible person at the defendant's residence for an individual or place of business for a corporation. All right, guys, we are done with satisfying due process. Let's now talk about complying with the relevant procedural requirements. In addition to complying with due process, plaintiffs must also comply with the relevant procedural requirements for their chosen method of service. State procedures for service of process vary, but in federal court, service is governed by Federal Rule of Civil Procedure 4. And Rule 4 has 4 stages for serving a defendant. Number 1, preparing the summons. Number 2, seeking waiver of service, which is optional. Number 3, serving the defendant if waiver is not granted. And number 4, filing proof of service or waiver. Let's begin with preparing the summons. When the plaintiff files their complaint, they also present their summons, one for each defendant, to the clerk of the court for signing. After the clerk signs the summons, the plaintiff can serve the defendants. The summons notifies the defendants that failure to appear and defend the lawsuit will result in a default judgment against them for the relief demanded in the complaint. And that's it, guys. That's it for preparing the summons. Now let's talk about waiver. A waiver of service of process is a legal document that allows a defendant to voluntarily acknowledge notice of a lawsuit without having to be personally and/or formally served with the complaint and summons. And the law encourages a plaintiff to seek a waiver and the defendant to waive formal service. It's pretty much the plaintiff going to the defendant and saying, "Hey, I'm suing you. Can you please legally acknowledge it? Or are you making me go through the whole process of getting a process server, finding where you live, etc." With some exceptions, plaintiff may request that corporate or individual defendants waive the requirements of service. Plaintiffs are not required to seek waiver, but they usually do because it's convenient for everyone involved. To request waiver, a plaintiff must send a defendant a written waiver request that 1. Is addressed to the individual defendant, a defendant's officer, or managing or general agent, or other authorized agent. 2. Names the court where the complaint was filed. 3. Is accompanied by a copy of the complaint, 2 copies of the waiver form appended to Rule 4, and a prepaid means of returning the form. 4. Informs the defendant using the form appended to Rule 4 of the consequences of waiving and not waiving service. 5. States the date when the request is sent. 6. Gives the defendant a reasonable time to return the waiver. And 7. Is sent by first-class mail or other reliable means. The defendant, by the way, has full discretion on whether to waive service. But it is encouraged, and this is how they do it. If the defendant waives service, then the plaintiff does not need to serve the defendant. That's a huge, huge plus. 2, the defendant gets more time to answer the complaint. Rather than 21 days after being served, the deadline becomes 60 days after the waiver request was sent. And the defendant waives any objections based on service, but does not waive objections based on personal jurisdiction or venue. So, defendant retains those protections to be able to object to personal jurisdiction or venue. What happens if the defendant does not waive service? If the defendant does not waive service, then the plaintiff must serve the defendant. And if both parties are in the United States and the defendant cannot show good cause for not waiving service, the court must order the defendant to pay the plaintiff's reasonable cost of effecting service, including attorney's fees. Woohoo! Done with waiver. Let's now move on to the meat. Serving the defendant if waiver is not granted. If service of process waiver is not granted, then the plaintiff must serve the defendant using one of the methods listed in Rule 4. The appropriate service procedure depends on who and where the defendant is. When defendant is an individual, under the Federal Rules of Civil Procedure, an individual may be served in a judicial district of the United States by one of the following traditional methods. Number 1, delivering a copy of the summons and complaint to the individual personally. Number 2, leaving a copy of each at the individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there. 3, delivering a copy of each to an agent authorized by appointment or by law to receive service of process. Or 4, following the state law for serving a summons in an action brought in courts of general jurisdiction in the state where the district court is located or where service is made. Let's talk real quick about what usual place of abode means. The usual place of abode is where the defendant is physically residing at the time of the legal action. Now let's talk about when defendant is a business entity. A plaintiff can serve a corporation, partnership, or association by delivering a copy of the summons and complaint to an officer of the defendant, a managing or general agent of the defendant, or the defendant's agent authorized to receive service. And that's it for serving the defendant if waiver is not granted. Now let's talk real quick about filing proof of service or waiver. After receiving the defendant's waiver of service or serving the defendant, the plaintiff must file proof of the waiver or service with the court. However, proof of filing, although required, doesn't invalidate otherwise sufficient service. So failing to file proof will not invalidate an otherwise sufficient and valid service of process. Boom, done with Rule 4 procedural requirements. We went over satisfying due process and procedural requirements, so we've covered most of this checklist, right? Except immunity. Super quick, let's do it. Just know this. The federal courts recognize immunity from service of process of parties, witnesses, and attorneys who enter a state to appear in another action, in another lawsuit. Also, if a party was induced by the plaintiff's fraud or deceit to enter a state so that he could be served, the service is invalid to confer personal jurisdiction. We did it, guys. That's it for service of process. And here is your roadmap again. I really hope this video was valuable to you, but if this is how you're feeling after this lecture, email me to questions@jsimplified.com.